Hi, everyone. Judge Andrew Napolitano here with Judging Freedom. Today is Friday, March 10, 2023. It's 9 o'clock in the morning here on the East Coast of the United States. These are our hot topics for today, and the first one of them is very hot. The District Attorney of New York City, Alvin Bragg, has signaled an unmistakable intention to bring criminal charges against former President Donald Trump. It gives me no joy to say this, and it gives me no joy to explain this, since, as many of you know, the former president and I have been personal friends for going on 40 years now, and I was privileged to have been consulted by him via telephone many, many times while he was in the White House. However, my job is to explain the law to you and to describe events as they happen. These are obviously out of my control. This is the weakest of the four cases against Donald Trump. The feds have two cases: January 6th, in which they will allege that he fomented an insurrection. No indictment yet. None of these are indicted yet. They're all on the investigation stage. Mar-a-Lago, in which the feds will say that he wrongfully took and retained national defense information secrets. Georgia, in which the state of Georgia will say he orchestrated a conspiracy to subvert the election returns in Georgia by participating in the filing of fraudulent and perjured documents, sending the wrong names as electors from Georgia to the Electoral College. And now this thing in New York, which basically says that when he paid $130 to Stormy Daniels in order for her not to speak publicly about the affair that she says she had with him, although she says it wasn't an affair because he paid her for the sex. He denied paying her and denied having sex with her. This was 3 weeks before the election in November of 2016. So in October of 2016, the New York prosecutors will allege Donald Trump used campaign funds to pay Stormy Daniels to remain silent, and booked the funds in his books, his corporate books and his campaign books, as legal expenses. He did that by depositing, the prosecutors will say, $130,000 in the trust account of Michael Cohen, his then lawyer, who then gave the money to a newspaper in Florida, which then gave the money to Stormy Daniels' lawyer, ostensibly to purchase her story, her exclusive rights for the newspaper. Then the newspaper supposedly changed its mind and said that we're not interested in your story. Keep the money, just don't talk to anybody about it. Okay, that's the case. There are some gaps in believability in this case, but that's the case. If everything that I just described to you can be demonstrated to a grand jury and to a trial jury, then the prosecutors will allege that former President Trump committed two crimes. One is the use of campaign funds for hush money, a violation of New York state law. And two is the intentionally false reporting of those campaign funds by sending them through that circuitous route from the campaign to Michael Cohen to David Pecker, who was at the time the president and owner of the National Enquirer, then to the National Enquirer, then to Stormy Daniels' lawyer, then to Stormy Daniels. That's a form of money laundering. We'll see where this goes. Now, how do we know that the prosecutors are ready to indict? Because New York state law says when you are ready to indict, you are required to tell the target of the indictment, hey, you can come and testify before the grand jury. Now, remember what a grand jury is like. There's no judge in there. There's no defense lawyer. Everything's in secret. So if Donald Trump were to go in there and testify, he does not know what the witnesses who've testified already told the grand jury. No lawyer would be there to question him. He would just sit in a witness box under oath and start talking. The prosecutors could question him and the grand jurors could question him. Any defense lawyer worth his salt will advise against this. It's an extremely dangerous environment for the reasons I just told you. You don't know what the grand jury knows. You would effectively be violating criminal law 101, which is don't deny before you've been accused. Trump has already done that in the Mar-a-Lago case, another story for another time. But back to New York. The DA in Manhattan is complying with New York state law, which requires him to give a defendant the opportunity to come in and testify shortly before he asks the grand jury to indict. He gave former President Trump that notice earlier this week, and it was leaked to the New York Times yesterday. There would be no reason for him to give that notice if he were not about to ask the grand jury to indict. Now, if Trump is indicted, he will have to leave wherever he is and fly to New York and appear in a New York State criminal courtroom in Lower Manhattan as a criminal defendant. I don't think you're going to see him in an orange jumpsuit or handcuffs, and I can't imagine that bail will be required. He has the most recognizable face in the country, in the world. He's hardly going to flee the jurisdiction. He doesn't even live in New York anymore. But this will be embarrassing, humiliating, distracting, and potentially dangerous to his liberty if he's indicted, because it'll require the consumption of time to defend the case. And of course, if he's convicted, then all hell will break loose about whether or not he goes to jail and what restraints would be imposed on him. So some of us have been predicting this for a long time. Again, on my part, not with glee. Some predict it with glee because they hate Trump. I don't. I still like him very much as a person and appreciate much of what he did in the White House, but I know how he gets under the skin of a lot of people: Republicans, Democrats, liberals, conservatives, progressives, libertarians. That's just his personality, and that personality suited him marvelously in 2016 when he defeated Mrs. Clinton. But now he is not in the court of public opinion. He can say what he wants about the prosecutors. I would advise him to say nothing. You don't taunt an alligator until after you cross the stream. You don't taunt the prosecutors until after the case is over and you have won the case. You don't want to give them an incentive to be more aggressive than they already are. So expect some fireworks soon. Trump's lawyers will probably tell the DA, forget about it. He's not going to testify, in which case the DA will ask for, receive the indictment. Then it's up to him when and how he reveals the indictment. While this has been going on, one of his well-known lawyers, very attractive young lady, she was on Fox many times when I was there, Jenna Ellis, pleaded guilty to ethics violations before the Supreme Court of Colorado. Colorado is where she is licensed to practice law. And what were the allegations to which she pleaded guilty? By asserting false, stolen election claims. So she admitted under oath that the allegations that she made in her capacity as Donald Trump's lawyer, that the election in 2020 was stolen from Trump, were concocted out of thin air, and there was no evidentiary basis for it. You see, lawyers can't say whatever they want to say unless they have a reasonable basis to believe that there is evidence to support it. I can sit here and express an opinion on anything I want. I'm doing so as an influencer, as a commentator. But if I put on a hat as a lawyer representing a client and I make a statement that I know is false, then the people who licensed me to practice law, in my case, it would be the Supreme Court of New Jersey. It's usually the highest state court in the state. Would come after me for violating the trust that's been entrusted to me. So as a private human being, or even a public human being in a non-legal capacity, you can express any opinion you want. But as a lawyer representing a client, you cannot make a statement unless there's evidence to support it. Jenna Ellis admitted to the Supreme Court of Colorado yesterday that there was evidence she was to support the claims she and others made in Trump's behalf that the election of 2020 was stolen. I hope they don't take her license to practice law away. I hope it's just a slap on the wrist. I don't know what the penalty will be. We will soon find out. Special Counsel Jack Smith, who's been appointed by Merrick Garland, the Attorney General of the United States, to lead the two investigations, I alluded to both of them earlier, against President Trump. One is the investigation of his role, if any, in January 6th. The other is an investigation into what he did and what he thought and what he intended with respect to the documents at Mar-a-Lago. Has asked a judge to reject President Trump's privilege claim. All right, what is this all about? A grand jury in Washington, D.C., investigating January 6th subpoenaed Mike Pence. Before Mike Pence could do anything with that subpoena, the federal prosecutor, Jack Smith, made an application before a federal judge to compel the former vice president to comply with the subpoena. The theory was he had no privilege whatsoever because he already wrote a book about this, and he said in the book everything that happened that he recalled that he wanted to say on January 6th. At the same time that Jack Smith made that motion, Donald Trump, who's not been subpoenaed, made a motion to prevent Mike Pence from testifying on the theory that Pence's testimony would violate executive privilege. Executive privilege is the right of the president to hear advice from those around him on matters of military secrets, diplomatic secrets, national security secrets. So Trump would have to argue that whatever he and Pence discussed on January 6th and the days leading up to it, it was military, diplomatic, or national security. The special prosecutor, the Department of Justice, filed papers yesterday demonstrating how, in the DOJ's opinion, it couldn't possibly be military, diplomatic, or national security, and therefore there is no executive privilege, and therefore Mike Pence will be compelled to testify. In my opinion, and I've known Mike Pence since before he was a congressman, which is before he was the governor of Indiana, which obviously was before he was vice president. We did radio together 25 years ago. In my opinion, Mike Pence is making a big mistake resisting this subpoena. He wants to run for the Republican nomination for president. He should say, I have nothing to hide and I'll be happy to testify because I already wrote about it in my book. But he seems to feel that he shouldn't have to testify because of the speech and debate clause. So he made an application. So there's three applications before the court. Trump's on executive privilege. The government's on make him testify because he has no privilege. And Mike Pence's on even though I was vice president, I was presiding over Congress, and therefore I enjoyed the protections members of Congress have, which is when you're on the floor of the Senate or the floor of the House, no one can force you to explain or justify what you did or said on the floor of the Senate or the floor of the House, known as the speech and debate clause. So those three applications are all before a federal judge. I think Mike Pence will lose them. I think Donald Trump will lose his. Pence will end up testifying and saying in secret to the grand jury what he has already said in public in his book. The Nordstring Pipeline. I've been talking about this with Larry Johnson and Phil Giraldi and Colonel McGregor and Scott Ritter and Matt Van Dyke and others. Those of you who are regular Judging Freedom viewers know about this. There's no serious dispute, but that the Nord Stream pipeline, which connected Russia to Germany and was a means for Russia to sell cheap natural gas to Germany, so cheap that the German utilities were able to resell it to utilities outside of Germany in Northern Europe. That pipeline was destroyed. Cy Hirsch, the great investigative reporter who exposed the My Lai massacre in Vietnam in the 60s, who exposed Watergate in a different way than Woodward and Bernstein did, who won a Pulitzer Prize for his expositions, gave a 19.5-page investigative report, released it about 3 weeks ago, demonstrating from 3 different sources that the pipeline was destroyed by Navy and CIA divers who packed it with explosives, and then 3 months later were given the go-ahead to explode it. The entire project was authorized by the President of the United States. Some people around the president objected to it. Why? Because it's a war crime. It's an attack on an ally. Attacked Germany, attacked German property, protected by German law enforcement, protected by the German military. No one has been able to refute what Cy Hirsch wrote, and mainstream media has been silent about it until last Monday. What happened last Monday? We got to go back to last Friday, a week ago today. A week ago today, Chancellor Schulz of Germany met with President Biden in the Oval Office. Just the two of them. Nobody else there. No translators. The chancellor speaks English. No aides to make notes. Just a snarky aside, makes one wonder if Joe Biden remembers what they talked about. But whatever it was, they talked privately. I guess they talked about the pipeline. Chancellor Schulz was humiliated when the pipeline was blown. It caused a cold and expensive winter. Fortunately for the Germans, a mild winter like we had here in the Northeast of the United States, but a cold and expensive winter nevertheless. My guess is that Chancellor Schulz said to him, Joe, this is killing me. My government's going to be voted out of office. We didn't know this was coming. We have no story to give out there. Everybody's reading what Cy Hirsch wrote, and everybody believes it because Hirsch's reputation is impeccable, and he wouldn't make something like this up. And he famously has three sources for all of his allegations. That resulted in the CIA leaking a phony story to the New York Times, which came out on Monday. And that said, there was a sailboat in the Baltic Sea at the same time that the explosion went off, and we're going to do some investigation as to who was on that sailboat. A sailboat? Come on. This was such a sophisticated, expensive, massive project. It could only have been done by a government. Nobody else would have had the resources, the know-how, and the ability to get down there. There were two subterfuges in the Baltic Sea of alleged military maneuvers, both of which were to cover the two times this happened. Two times. The divers went down and packed it with explosives. 3 months later, the divers went down to set a detonator. A week later, Joe Biden gives the order for the kill switch. The detonator goes off. I mean, they're looking for Gilligan on Gilligan's Island if they think that the public in Western Europe and in the United States will accept this nonsense that it was a guy in a sailboat. But that's the best that the CIA can come up with to cover its tracks. Remember Mike Pompeo? Nice guy. We spent a lot of time together when I was at Fox. The former director of the CIA and the former Secretary of State of the United States and a former officer of the CIA. The job of the CIA is to steal secrets, keep secrets, and lie about it. Some of their lies are believable lies. This one is a farce that a guy in a sailboat destroyed the Nordstream pipeline. Finally, yesterday, you may have forgotten this. There's a sedition trial going on in Washington, D.C., and it's a sedition trial of 5 Proud Boys. The trial's been going on for 3 months. The government alleges, 2 months, sorry. The government alleges that these Proud Boys were engaged in sedition. Sedition is a conspiracy to overthrow the government of the United States by force. I've argued that the government should not prosecute conspiracies that are impossible to carry out. This is an argument that defense counsel makes in every conspiracy case. Even if they had succeeded, even if it weren't a conspiracy, even if they actually attempted to do it, well, they couldn't have succeeded. How could 5 people overthrow the federal government by force? It's impossible to have accomplished. So my argument is the feds shouldn't waste their time and our money prosecuting people for conspiracy, which is a thought crime, to do something that's impossible to carry out. Nevertheless, the judge rejected that argument. The appellate court will reject that argument if it ever gets there. They always do, but it's worth making the argument anyway. Nevertheless, in the middle of the trial earlier this week, on Wednesday, the prosecutors realized they inadvertently gave national security secrets to the defendants, to the defense counsel who gave them to the defendants. What were the secrets? We don't know. This occasionally happens once in a while. Remember, there's an exchange of documents before a trial. In a criminal case, in a civil case, they call it discovery. So there's no surprises in the courtroom. The defendant knows what the plaintiff's going to present to the jury, and the plaintiff knows what the defendant's going to present to the jury. In a criminal case, the defendant knows what the government is going to tell the jury. The defendant is also entitled to what's called Brady material, not Tom Brady, but it's the same name from a famous case, United States versus Brady, which requires exculpatory material to be given to the defendant. Exculpatory material is information that the government has which helps the defendant or hurts the government. The government is required to share that. In the process of sharing that with the defendants in the Proud Boys case, the government inadvertently gave national security secrets. The same time that they discovered that, Tucker Carlson released his version of the January 6 tapes. So you had quite a brouhaha in the federal courtroom in Washington, D.C. on Wednesday, in which the defense counsel said, throw this case out. They've given us national security secrets. They don't want us to reveal these secrets. We can now reveal them. What else should they have given us that they didn't? Because this they gave us and they shouldn't. And B, look at what Carlson just revealed. We didn't know about that. We need to see the 40,000 hours of tapes to see if there is exculpatory material in there. Why should Tucker Carlson, I'm not being critical of Carlson, the Speaker of the House gave him all this. Why should Kevin McCarthy, the Speaker of the House, have this? Why should Tucker Carlson have it? We're defending people. The government wants to put them away for 20 years, and we don't have it. All of that came to a head in a federal courtroom on Wednesday. The trial was adjourned so that the judge can decide what to do with this brouhaha. I can't predict what the judge is going to do. I don't know who the judge is. I don't know the judge's track record. This judge would throw the cases out. More as we get it. Scott Ritter today at 1 o'clock Eastern on the latest in Ukraine. Our numbers have been going through the roof. I'm deeply grateful for all of you who continue to watch us. If you haven't subscribed, please do subscribe. Watch us on YouTube. More as we get it. Judge Napolitano for Judging Freedom.